Good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and so I do encourage you to speak to your attorneys before speaking on the record today, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me and are able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from confinement status, pretrial supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at first appearances if you are here on misdemeanors or municipal ordinance matters, but understand that is dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at first appearances. Following today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. As we're getting started this morning, I will go to our list of individuals who are requested to be called out of turn by the jails. I have some cases from Maine. Let's see. On page 10, I have Wayne Brown.
Judge, he is here, and it's a municipal ordinance case.
Well, good thing I have both Mr. Plant and Mr. Shape here.
Oh, you got the double team. Something's going on.
I know. Something's going on, right?
What's going on?
All right. I just need one of you. This is just for Wayne Brown. These are just the ones that we... Okay.
Which gentleman is this?
This is Mr. Wayne Brown on page 10. Okay. All right. Good morning, Mr. Brown.
Good morning.
Mr. Brown, you're before the court this morning on a misdemeanor capias. This is related to a municipal ordinance violation that says vehicle on beach without permission. I find probable cause, and your attorney, Mr. Shate, is with me in the courtroom this morning. And Mr. Shate, what are we doing in Mr. Brown's case?
It's a 2016 case. It's time served if he wants to accept it. If he doesn't want to accept it due to the age,
Yes.
We'd ask that he be ROR and come to court.
Okay, all right,
But it's
so,
up to Mr. Brown if you want to resolve it today, or would you like to come back to court and resolve it then?
yes,
And
so,
possibly have it dismissed.
all right, so Mr. Brown, you have two options today, okay? I see that this is a 2016 case. If you want to resolve the case today, then Mr. Shate has said the city's offer to you would be an adjudication of guilt with time served. If you don't want to resolve it today, then I'm willing to grant you an ROR because it's an older case, but understand that means that you'll have to come back to court on another day. So what would you like to do?
I would like to resolve it.
Okay, all right. Do you understand the offer, the adjudication time served?
It'd be a withhold.
Oh, it's a withhold, excuse me, it's a withhold of adjudication with time served. All right, Mr. Brown, you understand that?
No, what does that mean?
Okay, if it's a withhold of adjudication, that means that there would not be a conviction on your record.
Okay, I'll accept that.
Okay, all right, I'm gonna ask you a few questions before we're done. So, to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
All right, and now you can put your hand down. And Mr. Brown, do you understand everything we've discussed so far this morning?
Thus far, yes.
All right. Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
All right, and do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
I'm a U.S. citizen.
All right, and Mr. Brown, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence in this case will be a withhold of adjudication plus court costs. All right, good luck to you, Mr. Brown.
Thank you.
You're very welcome.
Right, though.
All
Back
right.
to my spot.
All right, and then I'll continue down our list of cases to be called out of turn, and Mr. Shade, I'll come back to your MOs.
That's all good.
All right. Okay, next on page 13 is Roberto Almy.
He's approaching, Judge, you hear me?
Thank you. I believe this is a change of charge, is that correct? All right, good morning, Mr. Almy.
Good morning.
All right, Mr. Almy, you're here on a change of charge this morning. On my finding sheet, it's showing as a felony capias, but I guess that's because it was generated as a result of the change of charge. So it looks like this, what was the original charge?
Almost said it $5,000, Your Honor, he posted.
Yes.
That was on a violation and pretrial, but he's being held on $1,100 worth of bond and other charges.
Yes.
I just asked that the court set the bond back at $5,000. His bondsman just needs to file an affidavit.
Okay. All right. Mr. Romero, any objection to that?
Judge, since I hear there's other matters holding him, I know Mr. Almy financially cannot afford to post a monetary bond no matter what happens with this case. The other things are still gonna hold him. I see he has a court date tomorrow, so this would be best litigated tomorrow in front of his division.
Okay, well, just to be clear, based on what Mr. Linder just told me, the bond, as it relates to this specific charge, was already posted. So if he needs to contact his bondsman to do the affidavit on that, that's fine.
It was already posted. So
For
you just
this
need to
charge, but
change
he
it from
has
the bond.
other
Gotcha.
bonds. Does that make sense?
Yes, I'll explain it to him.
Okay, all right, so I'll just reset it at $5,000 then. Okay? All right, thank you very much. Okay, I have two cases from Conti that were requested to be called out of turn. On page 15, Shaquan Roberson.
Judge,
Yes.
North Broward also requested to,
Who are the two at North Broward?
Mr. Burgess on page 22 and Humphrey on page 12.
Okay. All right. Good morning, Mr. Roberson.
Good morning, how you doing?
I'm well, thank you. Mr. Roberson, you're before the court this morning on an ad charge. This charge is for grand theft between $750 and $5,000. I find probable cause, and I will hear from the parties at this time. Is the state seeking anything beyond the standard bond?
No, Judge, he's got no bond holds.
Okay, Mr. Miller, anything you want to tell me?
Nothing to add here.
All right, so in light of the other issues that Mr. Roberson has holding him, I'll leave the standard bond in place on this charge, which will be $1,000.
I thank you, Your Honor.
All right, you're welcome, Mr. Roberson. Good luck to you, sir.
All right.
Okay, and then also at Conti on page 27 is Michael Miranda.
It's the last one on the docket.
All right, good morning, Mr. Miranda.
Good morning.
Mr. Miranda, you're here this morning on two change of charges. I see on count 4, this was originally burglary of an occupied dwelling unarmed. It has been changed to burglary of an occupied conveyance unarmed. And on count 5, it was originally grand theft, and it has been changed to dealing in stolen property. Mr. Linder, is that accurate?
It is, Your Honor.
right.
I'm asking, the bond was on the burglary dwelling,
Yes.
was set at $7,500.
Yes.
I'm asking that the court set the bond on the burglary conveyance at $2,500.
Okay.
I'm asking that the new bond on the dealing stolen property be kept in place at the standard bond amount.
All right.
I'm showing he has multiple bonds on other counts as well, not connected to this case.
Okay. Mr. Miller, you have any objection to those recommendations?
No, Judge.
Okay. So on the, on count 4, it'll be reduced to $2,500. And count 5, I'll leave the standard bond in place at $3,500.
Okay, what was the burglary change also? Can you repeat that,
It's,
please?
Mr. Miranda, that was the charge that was originally a burglary of an occupied dwelling. It's just been changed to burglary of an occupied conveyance. It's more of a technical charge, okay?
Okay.
All right, good luck to you, sir.
Thank you.
You're welcome. Okay, and then let me go to our cases for North Broward. First up will be Mr. Humphrey on page 12.
Morning, Your Honor. Thank you.
All right, thank you, Deputy.
Time served.
Good morning, Mr. Humphrey.
Good morning, Ms. Cough.
Don't get ahead of me now, all right? Okay, let's see here. Mr. Humphrey, you're before the court this morning on one charge of resisting an officer obstructing without violence. I find probable cause. And Mr. Linder, does the state have an offer for Mr. Humphrey today? I imagine he wants to resolve it based on what he said.
I suspect he'd like to resolve it for time served. One moment, Judge. I'm fine with the adjudication time served offer.
All right, so Mr. Humphrey, the offer, if you want to resolve it today, is an adjudication time served. Do you understand that?
Yes, ma'am. Your Honor.
And do you wish to accept that offer today?
Yes, ma'am, I do. Your Honor.
All right, I'm going to ask you a few questions before we're done. So to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am, I do, Your Honor.
Thank you. And now you can put your hand down. And Mr. Humphrey, do you understand everything we've discussed so far this morning?
Yes, ma'am, Your Honor. Yes, I do.
Is anyone forcing you to resolve this case?
No, ma'am, Your Honor. No one is.
Okay. Are you under the influence of drugs or alcohol?
No, ma'am, Your Honor.
All right.
Period.
Do you need any more time to speak with your attorney?
No, ma'am, Your Honor. I'm ready to go.
Okay. And do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am, I do,
Okay.
Your Honor.
All right. Have you ever been treated for mental or emotional illness?
I'd rather not. No, I haven't. It's just
If you
many
have,
years ago.
okay,
It's many years ago, plus 15 years ago.
that's absolutely fine, Mr. Humphrey. So is there anything about any mental or emotional illness
No,
today
ma'am,
that
no,
impacts
ma'am.
your ability?
No,
Okay.
No, Your Honor.
Okay.
No, ma'am.
All right, great. All right. And Mr. Humphrey, do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am, Your Honor. I understand that.
All right. And Mr. Humphrey, what plea do you wish to enter? Guilty or no contest?
Guilty.
All right. I accept your plea and find that it's freely and voluntarily given. As we discussed, your sentence will be an adjudication with time served. Good luck to you, sir.
Thank you, Ms. Corey.
You're very welcome.
All right,
Very
have a
welcome.
nice day.
You too. All right. Next up will be Frederick Burgess on page 22.
I understand that, but I'm in pain, bro. Well, I'm a plan, bro. I just got a metal rod in my femur, bro.
Mr. Burgess, Mr. Burgess, the longer you keep yelling at the deputy, the longer this hearing is going to take, okay? So listen, okay? You're before the court this morning on 7 charges. Count 1, resisting an officer obstructing without violence. 2, operating without a valid driver's license. 3, operating a motorcycle without eye protection. That is not for magistrate. Counts 4 through 7 are felony warrants for violations of pretrial. Those are not for magistrate. I find probable cause. And do the parties wish to be heard on count 1, which is the resisting count, Mr. Miller?
I got nothing, Judge.
All right. So I'll leave the standard bond in place on that. Mr. Burgess, on the warrants for the violations of pretrial, just so you know, those aren't for me to control. but those have $1,000 bonds attached to each of them, and you got a $100 bond on the resisting count. You understand?
The resistant, they don't have no, I could cop out today for the resistant, if the state willing.
Not today, sir, because you got the other issues that are pending right now. But that's the least of your worries. That's got a $100 bond on it, so you got to deal with those other warrants first, okay?
So the warrants have bonds though.
Yes.
I can bond out.
Yes, your total bond for everything is $4,100.
Okay.
All right.
Thank you, ma'am.
All right, good luck to you.
Hey.
Okay, now I have a sign-in. I'm assuming he's at Maine.
Mr.
If-
Krupnik, judge, is on page 16 of the court's
Correct.
docket.
If he's present at Maine, we'll take Mr. Lawrence Krupnik's case. He has family present in the courtroom.
Morning, Your Honor.
Good morning.
How are you today?
Well, thank you. Thank you. All right.
He's here, present, Judge, at Maine.
Thank you. Good morning, Mr. Krupnik.
Good morning.
Mr. Krupnik, you're before the court this morning on one charge of financial exploitation of an elderly person or disabled adult. I find probable cause for this charge. Before I go to the parties to hear their recommendations, sir, are you present this morning just to observe or to speak?
No, I'm here to speak on his behalf.
Okay, so let me tell you a couple things I say to everyone at first appearances.
Yes, ma'am.
Number one, everything that we say today is being recorded and can be used against you and potentially him at a later date. You
Yes,
understand? All right. Number two, since this is just the first appearance hearing, I'm only addressing bond and release conditions today.
Yes,
So
ma'am.
we're not addressing anything about the background of the case or anything like
Yes,
that.
ma'am.
Okay?
Yes, ma'am.
So if you would like to speak, I'm going to place you under oath. And then I'm just going to ask you to speak into that microphone loudly so that they can hear you at the jail, okay?
Yes, ma'am.
All right. Will you please raise your right hand?
Yes, ma'am.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And will you please state your full name for the record?
My name is Sean Christopher Kelly.
All right. And Mr. Kelly, will you please go ahead? Tell us what you want.
This is my mentor, Lawrence Krupnik. I'm a close family friend. I also live at one of his residences. He has strong ties to the community. He's never been in trouble before in his life for anything, ever. This has to be a misunderstanding. And he has real estate here. He's an accountant here local. He's got a bunch of clients that are in limbo right now. Everyone's like confused. And I just asked that you would release him on his own recognizance. He doesn't have the finances to do this. He was just released from the hospital not too long ago. He has a lot of medical complications. And the jail called me up last night and asked me to bring a bunch of his equipment in and all this other stuff, and I just have to convey with his family first to find out what they want to do. But I would just ask that you would release him on his own recognizance, if not a very low bail, because I have limited money also.
Are you the ones going to be posting his
I will
bail?
be helping and assisting, yes, ma'am.
Okay. All right. So what I'm going to do now is I'll go to the attorneys. I'm going to hear whatever they want to tell me, and then I'll make a decision from there, okay?
Thank you, Your Honor.
All right. So we will begin with the state.
Good morning, Judge. This is a second-degree felony. The gentleman is entitled to bond.
They
we can't-
They can't hear you.
Oh, I'm sorry.
That's all right.
This is a second-degree felony. The gentleman is entitled to a bond.
Yes.
However, one of the enumerated factors for Your Honor to consider today is actually the strength of the state's case. Your Honor will see in the PC that this was a gentleman who was doing the accounting and bookkeeping for a woman who had suffered from a stroke. There was set terms and agreements. He went outside of those parameters in the total sum of $24,000. When this case originally came in, it came along with 3 other professionals that were working for the victim, who is now deceased, and as organized fraud, but we filed separately on Mr. Krupnik. The other thing to consider, Your Honor, when placing a bond on this case is that this is a financial exploitation case, not a physical abuse type case. So the money of which he has allegedly stolen from the victim is now going to be used to post his bond and essentially afford him due process with an attorney. So we are asking that Your Honor set a $50,000 bond amount on the second-degree felony. Just with the level 7 offense alone, he does automatically score prison.
Are you requesting any other, you mentioned because this is a financial issue, you're requesting anything, any other special conditions for the bond?
No, there was mention that he is a practicing accountant. However, the state contends with that he is able to ethically practice as a CPA in the state of Florida, but that's not for now or then. He has lived at the same address for a long time, so we wouldn't be requesting any type of monitors or anything like that if he's able to post the bond.
Okay, all right, so Mr. Romero, let's go to you.
Just as you heard, he has very strong ties to the community. He's a homeowner. He resides in Hollywood. He still pays mortgage. I believe his mortgage is somewhere in the vicinity of about $2,000 a month. Now, Mr. Krupnik does receive Social Security, but in order to supplement his income, he does side work as far as accounting. Judge, as you heard, he has no prior contact with the criminal justice system. He's a registered voter in our community. He's been here since 1971. He is 72 years old. Now, the state mentioned as far as things that the court can take into account, two of the things that I believe the state left off is his history, which you heard, lack of history, any criminal history, and his ties to the community, as evidenced by a friend, not a family member, coming here to speak on his behalf. Judge, I have no doubt Mr. Krupnik is not a flight risk at all. From what he says, he is looking forward to having his day in court and disputing these allegations, and that they are allegations. But Judge, he's going to be reaching out to his son. He actually gave me the phone number of his son. I believe he works at Starbucks. Also, his friend here, Mr. Kelly, is going to help. I believe he's an electrician. I don't think they're going to be able to come up with what the state has asked for as far as $50,000. We're going to be asking for a $10,000 bond. I believe that's reasonable considering his basically lack of criminal history and his strong ties to the community and the fact that these are allegations, Judge.
All right, I'm going to set the bond in this case at $25,000. And I will not place any other conditions on Mr. Krupnik at this time as far as bond or release goes.
Thank you, Your Honor.
All right, thank you. Mr. Krupnik, good luck to you. Mr. Kelly, thank you for being here.
Ma'am, thank you, Your Honor.
All right. Okay. Thank you, you too. All right, I have our city cases here, since I've got Mr. Shade here. If we have them present, we'll go ahead and address the MOs. All right. First up will be Victoria Eisler on page 1.
Judge, she'd like to resolve both matters.
No problem, John.
Thank you.
Good morning, Your Honor.
Good morning, Miss Eisler. Miss Eisler, you're before the court this morning on 2 misdemeanor capiases. The first is a municipal ordinance violation for trespassing. The second is a state case for prostitution. I find
Oh my
probable
gosh.
cause. And Miss Eisler, both of your attorneys, Mr. Shate, who is acting as your attorney on the municipal ordinance case, and Mr. Miller, who's acting as your attorney in the state case, they're both with me in the courtroom. So let me first go to Mr. Shate. On the MO case, is there an offer from the city?
It was time served, Judge.
Okay, and Mr. Linder, on count 2, is there an offer from the state?
Push the little button.
Withhold court cost HIV test, Judge.
I went over the conditions, Judge.
You did speak to her about those?
Yes, but
Yes, ma'am.
All right, so Miss Eisler, I'm gonna say these just for the record so that, I know you've spoken with Mr. Miller about it, but I just wanna make sure you hear it from me, okay?
Yes, ma'am. Yes, ma'am.
All right, on count 1, which is the trespassing case, the city's offer to resolve that case is an adjudication of guilt with time served. Do you understand that offer?
Yes, ma'am.
Okay, and on the second offer, which is the prostitution case, the state's offer is a withhold of adjudication plus court costs, and there would be a requirement that you undergo HIV and STD testing and submit proof, not the results, but proof of that testing to the clerk's office within 30 days. Do you understand that?
Yes, ma'am.
All right, and do you
Yes,
wish,
ma'am.
do you wish to accept those offers this morning?
Yes, yes, ma'am.
Okay, so I'm gonna
Yes,
ask
Your
you a
Honor.
few questions before we are done. So to begin, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can put your hand down. And Miss Eisler, once again, do you understand everything we've discussed this morning?
Yes, ma'am.
All right. Is anyone forcing you to resolve your cases?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorneys?
No, ma'am.
All right. And do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that illness today that impacts your ability to accept this plea?
No, there is not, ma'am.
All right. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right. And Ms. Eisler, what plea do you wish to enter? Guilty or no contest?
No contest, Your Honor.
All right. I accept your plea and find that it's freely and voluntarily given. And I'll say it once again for the record. Your sentence as to count 1, the trespassing case will be an adjudication, time served. Since it's a trespassing case, there will also be a no return order to the location. Do you understand that?
Yes, ma'am.
All right. And then as to the prostitution case, once again, the sentence will be a withhold of adjudication plus court costs and the requirement that you undergo the HIV STD testing and submit proof. And you understand that?
Yes, ma'am.
All right. Thank you very much and good luck to you, Ms. Eisler.
Thank you.
Next is going to be Melinda Jouaz.
Hi, yes.
All right. Good morning, Ms. Jouaz.
Good morning.
Sorry, just give me one moment. All right, Ms. Jouaz, you're before the court this morning on one charge. This is a misdemeanor capias related to a municipal ordinance violation. I find probable cause, and Mr. Shate, your attorney's with me in the courtroom this morning. Mr. Shate, what are we doing with her case?
So the offer from the city of David be a withholding of adjudication, no return to the Walmart at 301 South University Drive in Davie.
Okay, a withhold and then a return, right?
Correct.
All right, so Ms. Jouaz, if you would like to resolve this case today, the offer would be a withhold of adjudication plus court costs, and there would be a no return order to the Walmart that Mr. Shate just referenced. Do you understand all that?
Yes, sir. Yes.
And do you wish to accept that offer today?
Yes.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Ms. Jouaz, do you understand everything we've discussed so far this morning?
Yes, I do.
All right. Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
I think we're okay.
Okay. Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
All right. Have you ever been treated for mental or emotional illness?
Yes.
All right.
I have.
Is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
Okay. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right. And Ms. Jouaz, what plea do you wish to enter? Guilty or no contest?
Guilty.
All right. I accept your plea and find that it's freely and voluntarily given. Your sentence in this matter will be a withhold of adjudication plus court costs, and there will be a no return to the Walmart that we discussed. And you understand that, ma'am?
Yes.
All right. Thank you very much and good luck to you.
Thank you.
Thank you. Next will be James Pownall on page 10. Is he at Maine?
Yes, Judge.
What's his name, Judge?
It's Pownall, Pownall, on page
Page 10.
10.
Just, let me look. I don't know. Name? James Pownall. Come on up, sir. He's approaching, Judge.
Thank you.
He was a little tired, that's all.
That's all right. It's early. All right. Good morning, Mr. Pownall.
Morning.
Judge, the situation with Mr. Pownell, these are pretty much, all these cases here, Judge, actually represent most of what he picked up in 2019. The last charge, the city, was actually in March of last year, or May of last year, so he has nothing from like maybe 9 months.
These are all January through May of last year?
Correct, so, they'd be a time served offer, and hopefully he's gonna continue to do what he's doing now, because they've had no contact with him up until they just picked him up on this, and it's not a new charge.
Okay, all right, so Mr. Pownell, for the record, you're before the court this morning on 7 misdemeanor capiases. These are all related to municipal ordinance violations from last year. I find probable cause. What Mr. Shea, who's acting as your attorney this morning, he's with me in the courtroom, and what he's telling me is that because these municipal ordinance violations are from basically January through May of last year, and you haven't been in any trouble since then, the city's offer to you on these cases is an adjudication time served. Do you understand that?
Yes, ma'am.
Okay, but understand, Mr. Pownall, that means that you gotta stay out of trouble after today, right? We gotta keep doing a good thing. It seems like you've had a pretty clean record since May, so we wanna keep that up, right?
Yes, ma'am.
Okay, so do you wish to accept the adjudication time served offered this morning on these cases?
Yes, Your Honor.
All right, so I'm gonna ask you a few questions before we're done. Will you raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. And Mr. Pownall, do you understand everything we've discussed this morning?
Yes.
Is anyone forcing you to resolve these cases?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Okay? Have you ever been treated for mental or emotional illness?
No.
All right. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right. And Mr. Pownall, what plea do you wish to enter? Guilty or no contest?
No contest.
All right. I accept your plea and find that it's freely and voluntarily given. Your sentence as to each of these cases will be an adjudication, time served. Good luck to you. Keep up the good work.
Thank you.
Next will be Joshua Latimer on page 10.
He's approaching, Judge, here at me. Come on up,
Thank
Mr. Latimer.
you. Good morning, Mr. Latimer.
Good morning.
Mr. Latimer, you're before the court this morning on 2 charges. Count 1 is first-degree petty theft. Count 2 is a misdemeanor capias related to a municipal ordinance violation. I find probable cause, and I'll hear from Mr. Romero and Mr. Shade first.
Judge, in speaking to Mr. Lattimore, I did talk to him as far as the offense of petty theft, $100 bond. At this time, he wishes to resolve it. We want to see if the state had a plea offer. I believe this stems out of Walmart in which the merchandise was recovered, so I don't think there's restitution issues. So we want to see if we can resolve it.
All right, let's see. Mr. Linder, is there an offer? Okay. While he's checking that, what's the offer from the
Judge, it's the
city?
same situation, basically with count, or the state case as it is with the, MO case.
Okay.
Be a withholding court costs, no return.
Judge, on the state offense, Mr. Lattimore wishes to accept the state's offer.
All right, Mr. Shade, is it gonna be the same on
It
the,
is, Judge, and, again, no return to that Walmart. Mr. Latimer, they do have a picture of you, hanging in their store, so if you go in there and they recognize you, you'll be arrested immediately for trespassing.
all right, Mr. Latimer, you understand all that?
Yes, ma'am.
Okay, do you wish to accept those offers today to resolve these 2 cases?
Yes, Your Honor.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. And once again, do you understand everything that we've discussed here this morning?
Yes, Your Honor.
Is anyone forcing you to resolve these matters?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorneys?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
All right. And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right. And Mr. Latimer, what plea do you wish to enter? Guilty or no contest?
No contest.
All right. I accept your plea and find that it's freely and voluntarily given. Your sentence in both cases will be a withhold of adjudication plus court costs. And once again, please understand there is a no return order to this specific Walmart location. You've heard what Mr. Shate has said to you today, so do not go back there. Do you understand?
Definitely won't.
All right. Thank you very much. Good luck to you, sir.
I think that's it, right, Judge?
Yes, that's all I've got for you.
Awesome, thank you.
Thank you. Of course. Thank you. All right, so, Mr. Miller, I have that one case that you requested the sign language interpreter.
Judge, I've received an email. The sign language interpreter will be here at 10:30.
Okay, all right, I'll leave that to the side then. All right, the next on my list is Shaquita McCrae. Thank you.
She's approaching, Judge.
I'm sorry? I don't know. What page is McCrae?
McCrae is on page 1, Judge.
Yeah. All right, good morning, Ms. McCrae. You're before the court this morning on a misdemeanor capias. This is related to a charge for petty theft. I find probable cause. I do see Ms. McCrae has a status hearing set for tomorrow morning with her division judge. Do the parties wish to be heard?
I came, they didn't change the address. When I had told them to change it to 1633, they never changed it. They left it at 1528, which is my mom's old address, but I changed it last night. When the lady changed it for me last night, so there wouldn't be a problem, because I didn't get the court date until the lady who stayed there, she finally found my mom and gave her the court date, so that's what happened.
Okay, well, Ms. McCrae, since this is a capias for missing a court date and you have a status hearing with your division judge tomorrow, the division judge is the one, listen, the division judge is the one that set the bond in this case, okay, not me. So I'm not gonna change the bond, so you can either post the $500 bond or you can go to the division judge tomorrow morning and you can absolutely give that information to the division judge.
So they're not gonna be able to, because it was a misunderstanding. I really wasn't even.
Ms. McCrae, I understand what you're telling me, okay, but what I'm telling you is that that's something for you to say to your division
But he
judge.
just said if it's a misdemeanor and what did you just tell us?
Oh, I don't know what you want to do, man.
No, I'm just saying, but you wasn't gonna talk to me anyway. I'm just saying the whole thing is it was a misunderstanding for me not to go to court.
Ms. McCrae, I understand what you're saying. I'm not saying that what you're saying is not true, but you're not listening to what I'm saying, okay?
That's messed up, man, for real.
All right.
So I gotta stay in jail.
Well, Ms. McCrae, you've got a $500 bond right now that your division judge set. So if you can post the $500 bond or have someone post it for you, then you can get out. But understand that either way, you have a status hearing with your judge tomorrow morning, okay?
So the judge that I see tomorrow can tell me if I can go home or not.
Absolutely. Okay?
I don't understand that.
Ms. McCrae, you have a division judge in this case, so that's the judge that's going to control what happens from here on out. All right? I know it's frustrating, but you'll see what happens tomorrow.
It's not even.
Ms. McCrae, that's going to be all for this morning. Good luck to you, ma'am.
No, they just want me to stay in.
Rima Rowe.
One moment, Judge.
No problem. You want me to sign an order?
I mean, no, if they want it, that's fine, but.
She's approaching, Judge.
Thank you. That's fine. All right, good morning, Ms. Rowe.
Good morning, Your Honor.
Ms. Rowe, you're before the court this morning on 3 charges. Count 1 is second-degree petty theft. Counts 2 and 3 are misdemeanor capiases that are each related to charges for petty theft. I find probable cause, and I will hear from the parties.
Judge, in speaking with Ms. Rowe, I did advise her what she's here for today. In speaking with her, I did explain to her some of the consequences. At this time, she's wanting to resolve these cases, so we wanted to see if the state had a plea offer for her.
Your Honor, frankly, I think she's gonna have to go to division to resolve 3 petty thefts at one time.
I think since all 3 of them are petty thefts, I think that that's correct.
Well, Judge, it is certainly still, I understand that the state doesn't have a plea offer, but it's certainly within the court's purview. If the court wanted to get involved, extend a plea offer. My understanding, and speaking with Ms. Rowe, she wishes to resolve these and basically forego her right to have a trial on these. These are misdemeanor offenses, Judge. I would ask at this time if the court would consider extending a plea offer on Ms. Rowe. She's 60 years old. She resides here in our community. She advised me that she cannot afford to post a monetary bond, and she wants to try and resolve these today, Judge.
Based on the fact that all 3 of these involve petty theft cases, and I'm sure you've already had a conversation with Ms. Rowe about the consequences of that and the fact that these can lead to felonies at a future date and subject her to jail time, at this time, I'm not comfortable extending a plea offer to her myself. If you want to discuss maybe some conditions of release, we'll see what we can do with that, but I'll need to hear that information.
Judge, in speaking with Ms. Rowe, I did talk to her as far as why she missed court. From what she advised me, Judge, she didn't know she had court. Now, she does have a residence. I don't know if notice was sent. I don't know if she was given notice in some other form. But from what she advised, she will be coming back to court. If the court's not inclined to releasing her ROR, we'd ask the court on these non-violent offenses if the court would consider releasing her under supervision.
Okay. While I am waiting to hear from Mr. Linder, I just want to confirm, because I have a couple of different addresses that I'm showing for her. What's
Now,
her
she
actual
just-
address?
Well, here's the thing, and I think this may have led to some of her confusion. She believes that the address may have potentially been going to her address in Ocala. She doesn't reside there anymore,
It
Judge.
didn't. It didn't.
Oh, it didn't?
No,
I have a
went to-
Hollywood address and a plantation address.
I don't live in Hollywood.
It would be the plantation address, Judge.
I'm not gonna say the whole address on the record, but is that the 1621 address?
Yeah, but I lived in Ocala for a short time, and I just came back in July, last July.
That's where the notices on both cases went to.
They did go to the Ocala address?
No, the plantation.
Oh, right, the plantation address, right.
Yeah, because they were unable to serve it at that address. That was the address that was provided.
Do you know, Judge, when the notices were sent out?
Yeah. I got the court dates, so I can tell you. One of them is from October 9th of 2018. The other is April 9th of 2019.
So that's what led to it.
Yeah,
She was residing in Ocala, and she moved back to that plantation address last year, and she never updated the clerk's office.
I didn't know.
All right. Is there any objection to me putting her on standard pretrial from the state?
It's fine, Judge.
All right. Ms. Rowe, I'm going to, because of the nature of these offenses and the fact, I understand you want to resolve them, but I'm not going to resolve them today. I'm willing to release you without the monetary bond, but you're going to be put on standard pretrial supervision. That'll have a reporting requirement to it. Mr. Romero is going to give you some information there regarding pretrial supervision. Though you're going to be released today, you will need to report to pretrial supervision within 24 hours. If you fail to report to them, as I have instructed you, a warrant will be issued for your arrest. Do you understand that?
I understand.
Okay. Additionally, I'm going to say to you, because two of these, at a minimum, two of these are active cases, that means there will be future court dates that are generated. It is your responsibility to make sure that the clerk's office has your correct address so that you get notice of them, and it is your responsibility to be in contact with your attorneys regarding these cases, okay? If you miss future court dates, then warrants can be issued for your arrest, and we can end up having this conversation again, but it'll have a different result. Do you understand?
Yes, Your Honor.
Okay. All right. Good luck to you, ma'am. All right. Next will be Kelly Shapiro.
Judge,
Line up.
Yes.
Ms. Shapiro has private counsel Scott Sale. I spoke with Mr. Sale this morning. He would like to appear by phone, if it pleases the court.
He's not appearing by phone. If he wants me to reset it till this afternoon, I'll do that.
I can call him, Judge. Can
All right.
put
I
this
will,
on
Ms.
recall?
Shapiro, I'm going to put your case on our brief recall so they can call your attorney and see what he wants to do, and I'll call you back up in a few minutes.
Okay, thank you.
All right. Roberta Bowles.
North Brow, John.
Thank you.
Welcome.
All right. Good morning, Ms. Bowles.
Yes, Your Honor.
Ms. Bowles, you're before the court this morning on 2 ad charges. Count 7 is possession of cocaine, and count 8 is possession or use of drug paraphernalia. I find probable cause, and Mr. Linder, is the state seeking anything beyond the standard bonds in this case?
No, Judge, she has a no bond hold on a DOP for trafficking.
Okay. All right, so Ms. Bowles, since you have the no bond hold pending, I'm gonna leave the standard bonds in place on these 2 ad charges, okay?
Yes.
All right, thank you very much. Good luck to you, ma'am.
Your Honor, may I say one thing?
What's that?
I don't know what's happening there because none of this is true. My granddaughters are gonna get me a counsel
Okay,
sometime today.
okay, good.
Is there any way I can get out on a monitor or anything so I can try to take care
Well,
of this?
Ms. Bowles, the issue is if you have a violation of probation, that has a no bond hold on it, and that means that you'll have to go in front of your division judge to address that issue. I don't have the ability to change it, okay? So, let me just ask, Mr. Linder, does she have a VOP date, a hearing date set?
She's got a status conference in front of Judge Porth on the 10th,
Okay.
and then a status hearing in front of a general master on the 30th of this month.
All right, so Ms. Bowles, you're gonna be, today is the 4th, and you have a hearing with your division judge on the 10th. So, so you'll be seeing the judge then, you can address everything at that time, all right?
It looks like she saw Judge. It looks like she saw Judge Porth yesterday.
Okay, okay. All right, Ms. Bowles, good luck to you, ma'am.
Thank you.
Calling Kelly Shapiro, Judge.
Yes. All right, let's go back to Ms. Shapiro's case. Okay, all right, Mr. Miller, were you able to get in touch with her private counsel?
Judge, I was. I can tell the court that Ms. Shapiro has one case
Yes.
that's in Odyssey. It's in the clerk's computer.
Okay,
My office is the attorney of record on that case. However, Mr. Sale has filed a notice of appearance.
okay,
That case was before the court yesterday and has been reset for arraignment to the end of this month. This case, these additional charges are not yet appearing in Odyssey. Mr. Sale is advising he does not represent her yet
on these charges. Okay,
and that we can proceed.
okay,
I believe that these charges were addressed yesterday in court, according to Mr. Sale.
okay.
And the arraignment will be set for the 31st of this month. With that said, we're just going to ask the court to keep the bonds as currently set.
Okay, is there any objection from the state to leaving the standard bonds in place? All right, so Ms. Shapiro, based on all that information, it sounds like you went in front of your division judge for an arraignment hearing yesterday, is that correct?
Correct.
All right,
Correct.
so since you were coming in today, this morning on ad charges, but since they were actually addressed yesterday, it's just a technical issue that you ended up here today. So because you already went to your arraignment hearing yesterday and you're going to go back in front of your division judge for the next hearing date, I'm going to leave the standard bonds in place on these. Mr. Miller has spoken with Mr. Sale, as you heard him
Okay.
say, so he'll be able to address these with you at a future date, all right?
Great, thank
All
you.
right, good luck to you, ma'am. All right, Mr. Miller, thank you for clarifying that.
Judge.
Evelyn Garita,
Also, Paul Ryan, Your Honor.
this is,
Spoke with Miss,
this is just on two, right?
yes, I spoke with Ms. Garita earlier this morning. She's aware of the immigration hold, and has asked that she be allowed to make her call. She hasn't been given a free phone call yet.
A call? Okay. All right, good morning, Ms. Garita.
Good morning.
All right, Ms. Garita, let me just read for the record. I know Mr. Miller's already discussed this with you, but you're here this morning on an ad charge. This is for the immigration hold that he discussed with you. I find probable cause, and Ms. Garita, I'm sure that you discussed this, but I just want to say it so that you hear from me also. There's a no bond hold since it's an immigration hold, which means that you would go before an immigration judge to address that issue. And if you, does she need me to sign a phone order, or is this just?
Judge, I don't know if the detention facility needs an order or if they can just tell the court that they're gonna give her a phone call.
Deputy,
What is she trying to do? I
she
have
just,
no idea what
she
she's
needs to make a phone call.
What?
Yeah, because I haven't been able to contact either a lawyer or my relatives, any of my relatives. I tried to use the number that I was given for the free call,
Right?
but I wasn't able to get in touch with them, with anybody, with any relative.
So you did use the phone, you just couldn't get in touch with them.
Yes.
Okay, all right, so,
That's no problem. I'll give her a phone call, Your Honor.
all right, thank you, Deputy, I appreciate it.
No problem.
Okay, all right. So, Ms. Garita, you'll get another chance to call them, and if you're not able to get in touch with them, then you can let your attorneys know that. They'll be able to come to you so that they can discuss that with you, all right?
Okay.
Okay, good luck to you. Thank you. Thank you, Deputy.
And I'm sorry, about the charge for domestic violence and stuff. Like I want to play not contest. I mean, because I'm not.
I can't, that's not something that we can plea out at first appearances, ma'am, so that's something that you'll have to address with your attorney at a later date, okay?
Okay. All right.
All right,
Thanks.
thank you very much.
Judge, she was already, ROR'd on count one.
I thought so.
That kicked in the 48-hour hold.
Okay, all right. Okay, next will be Star West.
Ms. West is at North Broward.
Okay, thank you. Good morning, Ms. West.
Good morning.
Ms. West, you're before the court this morning on two charges. Count one, resisting an officer obstructing without violence. Two is a felony probation violation, which has the no bond hold. I find probable cause, and Ms. West, you're gonna have a hearing with your division judge tomorrow morning to address the violation of probation. You understand?
Okay.
All right, good luck to you, ma'am.
Courtroom.
Tammy Lewis.
And Judge,
Medical research, Your Honor.
Okay. Yes, Mr. Miller?
our sign language interpreter is present for,
Lowers.
yes, Judge.
Which facility is that?
North Broward.
Oh, okay. All right. Yeah. So you can just go right to the podium. That's okay. Yeah, that podium right there. That's where the camera points. All right, and I'll just place you under oath. Will you raise your right hand? Do you swear or affirm to interpret in sign language to the best of your ability? Thank you. All right, and will you please state your name for the record?
Donna Fernandez, for the record.
Thank you, Ms. Fernandez.
Your Honor.
2-2.
All right.
Just wanna
Good
make
morning,
sure that he
Mr.
sees me.
Lowers.
I'm asking if he can see me. Can you move the screen? Yeah, I think
They went in front of me?
I think
You can
so,
come.
yeah.
Yep. Thank you. We haven't had it yet. That's fine.
I haven't been in your courtroom, Your Honor, so I wasn't.
That's absolutely fine. You want to come right here with me? Here. I'll move over so you can come here. I think they're right if you're right in front of here. Okay, let's see.
Yes, I can see you now. You're good.
Okay. All right. Mr. Lowers, you're before the court this morning on two charges. Count 1 is burglary of an occupied dwelling, unarmed. Count 2 is second-degree petty theft. I find probable cause for these charges. At this time, I will hear the parties' recommendations as to bond on count 1, which is the burglary charge.
Your Honor, the state's requesting a $7,500 bond. No victim contact, no return.
Can I say something? What do you mean by burglary of a dwelling?
The boat that you're alleged to have entered,
I'm sorry, the boat?
the boat,
Oh, thank you.
was that person's residence.
Oh, no.
Okay.
I didn't touch any boat.
Mr. Lowers, one moment. Just listen for a moment. Listen. Mr. Miller is with me in the courtroom. He is acting as your attorney for this morning's hearing. I want to advise you that today's hearing is not about the background or facts of the case. We're only addressing bond and release conditions.
Judge, may I voir dire my client regarding his ties to the community?
Yes, you may.
Well, Your Honor, I wasn't done.
Oh, you weren't done.
No.
All right.
Oh.
Good, and
I will-
I wasn't. I wanted
Okay,
to explain
go
the
ahead,
bond.
go ahead.
I mean, the
Go ahead. All right. We'll finish hearing from Mr. Linder on behalf of the state.
So, as already mentioned, this was someone's residence and it was occupied at the time. Additionally, Mr. Lowers was arrested approximately 2 weeks ago for carrying a concealed firearm. And
Mr. Lowers, please stop doing that.
is out on a $1,000 bond. Nothing further.
1,000?
1,000.
1,000.
All right. Now we will go to Mr. Miller. As I said, for clarification, Mr. Miller is acting as your attorney for this morning's hearing, Mr. Lowers. So I don't want you to say anything right now. I just want you to wait and let me hear from Mr. Miller.
Mr. Lowers, your bond, the state is requesting your bond be set at $7,500. Can you afford to post that bond?
No.
How much bond can you afford to post, sir?
$500.
And Mr. Lowers, how do you support yourself? Do you work? Are you receiving SSI?
I work.
Okay.
I work at a retail.
Okay. And do you have a place to go once you're released?
Explain. I told the officer, why did they arrest me? Why
Okay.
are they arresting me?
This is going to be addressed another day in another courtroom. Today is just about the bond. How long have you lived in South Florida, Mr. Lowers?
Long time. I'm asking for clarification. 30 years.
Judge, based on his ties to the community, the fact that he is working, he cannot afford to post a $7,500 bond. I would ask the court to set the bond at $2,500.
Mr. Linder, is there any prior history besides the case that you mentioned before, which Mr. Lowers is currently out on bond for?
Yes, Judge. Aided but a trespass in 08. 2 thefts in 2004. Aggravated assault with a deadly weapon in 1998. I see he was picked up in 2017 on a capias for a failure to appear in a battery, a domestic violence battery that was ultimately dropped.
Mr. Lowers, do you have a permanent address?
He'll come back. He'll come back.
Mr. Lowers, where do you live?
I stay at a friend's home.
What city is that in?
I don't remember. I don't remember the name. Your Honor, I sleep at a friend's house. Oh, I can stay at a friend's house sometimes, but I am homeless.
All right, I'm going to set the bond at $3,000. There will also be an order of no return and no victim contact. Mr. Lowers, so that you understand these orders, the no return order means you are not to go to the location that is at issue in this case. And one moment.
I didn't go back there, so I don't
And the
know.
no victim contact order means whether you know this person or not, no being in the same place at the same time, no contact of any kind with the alleged victim. Do you understand that? Okay.
Yes, understood.
Okay, all right, thank you very much. Good luck to you, sir.
Okay.
All right, that That's it for today. Thank you very much. I appreciate it. Oh, here, I'll sign it before you go. The next on our list is Sabrina Brito.
She's here present, Judge.
Hey, Jim.
Approaching.
Thank
Brito?
you. Thank you again. All right. Good morning, Ms. Brito.
Good morning.
Ms. Brito, you're before the court this morning on 2 charges. Count 1, possession of cannabis, 20 grams or less. Count 2 is possession of amphetamine. I find probable cause, and I'll hear from the parties.
Judge, in speaking Ms. Brito, I'm going to be requesting a straight ROR. My understanding, she's been here her whole entire life. She's 25 years old. She goes to school and works. She's currently attending Florida International University, studying political science. She intends on graduating this summer. Besides going to school, she works. She works at Margaritaville as a retail attendant, where she's been working there for over 3 years. She has very strong ties to community, graduated of Miramar High School, class of 2013. She lives here with her mom. Judge, based on this being a nonviolent offense, her strong ties to community, and her lack of, as far as criminal priors, as far as convictions, I don't know if I said that she's a registered voter here in our Broward County. I'd be asking the court to consider an ROR on her behalf at this time.
All right, Mr. Linder. All right, Ms. Brito, I'm going to grant the request and ROR you on count 2. I need you to understand Mr. Romero is going to give you some information. Though you are going to be released today, that does not necessarily mean that's the end of the case. So it's going to be your responsibility to be in contact with your attorneys in the clerk's office so that you know if there are any future court dates you need to be present for. Do you understand that?
Yes, ma'am.
All right, thank you very much. Good luck to you. Teresa Crane.
Judge, it looks like she's on loan.
I wish. All right, so we'll reset her. Kimberly Gleaves.
That's a medical reset.
Thank you. Marcel Neal.
Maine.
Approaching Judge, Maine. Oh, he's going to be right up.
Okay.
Come on up, sir.
Understood. I was just asking if she's here.
All right. Good morning, Mr. Neal.
Good morning, Joe.
Mr. Neal, you're before the court this morning on an out-of-state felony hold. I find probable cause. This is a hold out of the state of Georgia, Mr. Neal, and it has a no bond hold on it. So you'll be going before the extradition judge probably on Thursday so that you can address how that matter is going to be handled. All right, good luck to you, sir. Colin Kerr.
He's at North Broward, Judge, requesting a psych screen for Mr. Kerr.
Yes, Your Honor.
Good morning, Mr. Kerr. All right, Mr. Miller.
Good morning.
I'm sorry, I missed what you said.
I'm requesting a psych screen for him.
I'll sign the order.
Thank you.
All right. Mr. Kerr, you're before the court this morning on 1 charge of domestic battery by strangulation. I find probable cause. And at this time, I will go to Mr. Linder and hear the state's recommendation as to bond.
Your Honor, I'm requesting a $50,000 bond, pretrial release of the GPS monitor, level 1, no victim contact, until more information can be provided to a judge with better alternatives. In addition to the allegations in this case, which causes me great concern for the safety of the victim and the community, Mr. Kerr was arrested in 2018 in Palm Beach County for domestic violence battery by strangulation. That was dropped. As referenced in the report, he does have a pending case in the state of Kentucky, first-degree burglary, The arrest was February 3rd, 2020. As indicated by the officer, he's on pretrial release for that. Frankly, I don't even know if he has permission to be in Florida at this point in time.
Judge, I can advise the court that my client has advised me that he is a union carpenter, that he has been living in South Florida off and on since he was 6 years old. He does have a place to reside separate and apart from the alleged victim, and would have no objection to the court requiring mental health examination on the outside. However, the $50,000 bond is quite beyond his reach.
All right. Okay, based on the circumstances, which include both the allegations before the court and the pending case out of Kentucky, which I'm not sure what's going to happen with that, I'm going to set the bond at $25,000, and if Mr. Kerr does post that bond, he will be placed on pretrial supervision with a level 1 GPS monitor. There will also be an order of no victim contact. Mr. Kerr, so that you understand the no victim contact order, with respect to the alleged victim in this case, that order means no being in the same place at the same time as that person. That includes no phone calls or text messages to that person, and no third-party contact or social media contact with that person. Do you understand that, sir?
Yes, but she's my friend on Facebook, so can you tell her to delete me or something?
Well, the best thing for you to do would either be for you to delete her or just to not be on Facebook for the time being. All right?
Okay.
Okay.
All right.
All right. Thank you very much. Good luck to you, sir.
Thank you.
Tevin Butts.
He's here, present, Judge and May.
Thank you. Good morning, Mr. Butts.
Good morning, Judge.
Mr. Butts, you're before the court on one charge of aggravated battery, where offender knew or should have known the victim was pregnant, domestic violence. I find probable cause, and I will hear from the parties. Okay.
Your Honor, the state would be requesting a $15,000 bond, pretrial release of the GPS monitor, no victim contact. This is based on the level of violence, also the allegation that the defendant struck the victim, who was approximately 5 months pregnant at the time of this incident, in her stomach. There's been violence in the past in this relationship. In 2018, Mr. Butts had a battery against the same alleged victim. In 2016, he was convicted of burglary of a dwelling and grand theft. 2015, robbery by sudden snatching. 2015, possession of PVP. 2015, petty theft.
Right. Mr. Romero.
Judge, I believe there's a lot more to this than is probably written on the probable cause affidavit. My understanding, speaking Mr. Butts, he doesn't know anything about it. Judging by the case number, it happened some time ago last year. Mr. Butts has advised me that a lot of this is basically motivated by the victim. Can't accept the fact that Mr. Butts broke up with her and moved on. So, in speaking Mr. Butts, he's also contacted law enforcement on the alleged victim. But having said all that, Judge, he's looking forward to disputing these allegations. I told him today is not his trial date. Now, he does live apart from the alleged victim. He lives with his aunt in Fort Lauderdale. My understanding, he is working. He works at Lanier Staffing, where he's been there for about 2 years. It fluctuates. You get paid anywhere from $60 to $100 a day. Judge, he's going to be reaching out to his aunt and also to his girlfriend to help post his monetary bond. He's quite confident that they're going to help him, but they're not going to be able to afford the $15,000 which the state has asked for. Judge, we're gonna be respectfully asking a $5,000 bond on Mr. Butt's behalf at this time. And Judge, my understanding is he hasn't seen this alleged victim in over 5 months, Judge. He doesn't want to see her, so he will be abiding by the court order as far as no contact, but he will be coming to court.
And Judge, just to advise the court, the allegations in this case are more than a year old, and Mr. Butts has not been arrested in Broward County since 2018.
Thank you. The bond in this case will be set at $8,500. If Mr. Butts does post a monetary bond, he will be placed on pretrial supervision, the level 2 GPS monitor, and there will be an order of no victim contact. Mr. Butts, so that you understand the no victim contact order, I'm sure Mr. Romero has already discussed it with you, but so that you hear it from me, that means no being in the same place at the same time as the alleged victim. Since you'll be wearing the GPS monitor, that will include a 500-foot stay-away order from this person. The no contact order includes no phone calls or text messages to this person, and no social media contact or third-party contact as well. Do you understand that?
Yes, ma'am.
Thank you.
One moment, Judge.
Okay. Good morning. That's correct.
Judge, nothing at this time.
Okay, all right, thank you. Good luck, Mr. Butts. Eduardo Ortiz Rubio.
Maine.
Judge, Spanish interpreter.
Okay. Markendi Mombranch.
He's here, Judge. Approaching.
Good morning, Mr. Mombranch.
Good morning, ma'am.
Mr. Mombranch, you're before the court this morning on 2 charges. Count 1, resisting an officer obstructing without violence. Count 2, trespassing on an unoccupied structure or conveyance. I find probable cause, and I'll hear from the parties if they wish to be heard.
Yes, Judge. And speaking to Mr. Mombranch earlier today, he wishes to resolve this matter today, Judge. So we want to see if the state had a plea offer for him.
Okay.
Offer be adjudication time served, Judge.
Judge, he wishes to accept the state's offer.
Okay. All right. Mr. Mombranch, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can put your hand down. And Mr. Mombranch, do you understand everything we've discussed so far this morning?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right. And Mr. Mombranch, what plea do you wish to enter? Guilty or no contest?
No contest.
All right. I accept your plea and find that it's freely and voluntarily given. Your sentence in this case will be an adjudication with time served. Good luck to you, sir. Christopher Bennett.
He's approaching, Judge.
Okay. Good morning, Mr. Bennett.
Good morning, Judge.
Mr. Bennett, you're before the court this morning on a misdemeanor capias related to a charge for driving with a suspended license. I find probable cause. And Mr. Romero, what does Mr. Bennett want to do?
Judge, and speaking to Mr. Bennett, he wishes to resolve this matter. We want to see if the state had a plea offer for him.
Okay.
One moment.
All right.
an adjudication, court cost, time served.
Okay.
This will be the second.
This is a second.
Yep.
He wishes to accept the state's offer, Judge.
All right. Did you discuss the, if there's a third with him?
I did, Judge.
Okay. All right. Mr. Bennett, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. And now you can put your hand down. And Mr. Bennett, do you understand everything that we've discussed here this morning?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes.
All right. And Mr. Bennett, what plea do you wish to enter? Guilty or no contest?
No contest.
All right. I accept your plea and find that it's freely and voluntarily given. Your sentence in this case will be an adjudication with time served. Good luck to you, sir. Gordon Cleary.
Maine.
Thank you.
He's a freshman.
Morning, Mr. Cleary.
Morning.
Mr. Cleary, you're before the court this morning on one charge of trespassing on an occupied structure or conveyance. I find probable cause. Mr. Romero, what does Mr. Cleary wish to do today?
Judge, Mr. Cleary would like to resolve this matter today.
Is there an offer from the state?
Your Honor, from what I can tell, the offer is going to be adjudication, 5 days in county jail. He was arrested for trespassing at the same location last month, and I'm also taking into consideration what he was allegedly doing while he was trespassing.
Okay.
Judge, one moment, please. Sorry, Mr. Linder, was he given a notice to appear on that arrest last month? Because I'm showing his last arrest before yesterday was in May of 2019.
20, but the case out. January 3rd, he was arrested. Had his first appearance on the floor.
Okay. Mr. Romero, what would he like to do?
Judge, if I may have one moment to speak with my colleague.
Go ahead.
Dale, can you call? Oh, we're calling you.
Okay.
Courtroom.
Turn the mic off.
So, Your Honor, I'm looking at the clerk's website, which does indicate that he was arrested for trespass back in January. Prior to that, it was looks like the May 2019 arrest.
Judge, respect, I did advise Mr. Cleary as far as the location. He says he won't go there anymore. But at this time, Judge, we're asking if the court, would consider releasing Mr. Cleary ROR. He's, homeless, and there's no one that's gonna be able to post a monetary bond. From what I hear, he hasn't had any recent major contacts with the criminal justice system. So, Judge, I'm asking if the court would consider an ROR on Mr. Cleary's behalf.
Well, I mean, the most recent arrest was involving the same location last month, so.
Right, but it wasn't, my point was it wasn't violent, it wasn't a serious offense, it was another trespass offense.
All right, Mr. Linder?
Judge, all he has to do is, first, all he has to do is stay away from this location. And two, he doesn't need to be doing what he was doing. People, these business owners have a right not to have people defecating on the side of their business, and customers have a right not to have to encounter that when they're going to see a dentist.
That's not the response that I was waiting for.
Well, I don't know what you were, yes, you said, that was my thought, Your Honor, in response to what Mr. Romero stated.
I'm gonna put him on pretrial supervision if he wants an ROR.
He does wish to accept that, Judge.
All right, Mr. Cleary, a few things that you need to understand. Mr. Romero is going to be giving you some information regarding pretrial supervision. Though you're going to be released today, you must report to pretrial supervision within 24 hours. If you fail to report to pretrial as I have instructed you, a warrant will be issued for your arrest. If you are picked up, you will end up back here. We will be having the same conversation with a very different result. Do you understand that?
Yes.
All right, there's going to be a no return order in place as to the location that is at issue in this matter. That means you are not to return to that location. Do you understand that?
That's fine, yes.
All right, thank you. Okay, I believe we have our interpreter present. Before I go to Mr. Ortiz Rubio's case, do we have any other cases we know of that are going to require an interpreter so I can pull them out?
Yes, Judge, two gentlemen on page 20 of the court's docket. First gentleman is Mr. Lazaro Rodriguez. The second is the person following him, Mr. Marcos Ruzan.
Okay, Mr. Miller, do you have any other ones besides those?
I'm not aware of any others, Judge.
Okay, let me go ahead and pull them out and then we'll get started.
Judge, on Mr. Ortiz Rubio's case.
Yes.
KPS in this case issued on the 24th of February, I'm sorry, the 26th of February. He was in custody on the beginning on the 24th.
Just give me a moment, just give me a moment. It's not for the interpreter yet because I haven't started yet. Okay, first, for my interpreter,
Yes.
Bryant, will you please raise your right hand? Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
Yes, I swear.
And will you please state your name for the record?
Sandra Bryan.
All right, thank you, Ms. Bryant.
Thank you.
Good morning, Mr. Ortiz Rubio.
Buenos días, señor Ortiz Rubio.
Maria.
Good morning.
You're before the court this morning on an ad charge.
Está delante del tribunal esta mañana por un cargo adicional.
This is a misdemeanor capias related to a trespassing charge.
Esto es un delito menor con una orden de captura KPS relacionado con una entrada ilícita.
So I was advising the court, he was arrested on February 24th.
Como le dije al tribunal
On another
anteriormente,
matter.
lo arrestaron el 24 de
That is
febrero
completed.
por otro caso.
I'm sorry. He is sentenced in that case.
Fue sentenciado en ese caso.
This capias was issued on the 26th. He was actually in custody.
Y esta orden de KPS se ordenó el día 26, ya que estaba detenido.
I don't know if he wants to resolve the matter or not, but I don't think we really need to do anything since he's not leaving till, oh, no, he's
No sé
he's
si
done.
quieres
He's
resolver
done.
el caso, porque no se va a salir de
So
todos modos, no se
I
va
would
a ir.
ask the court if he doesn't want to resolve it, if the court would consider ROR.
Yo le pido al
since
tribunal que si no lo quiere resolver, que
it's not his
considere
fault.
libertad sin fianza, porque no es culpa de él.
Okay, well, let me first ask Mr. Romero, what would Mr. Ortiz like to do today? Is he interested in resolving?
¿Qué quiere hacer?
He is, Judge.
Si lo quiere resolver hoy.
Okay, Mr. Linder, does the state have an offer in this case for Mr. Ortiz?
Señor Leonard, que si el Estado tiene una oferta para el señor Ortiz hoy.
Adjudicated court cost, no return.
Fallo, el costo del proceso y que no regrese al lugar.
He wishes to accept the state's offer, Judge.
Él quiere aceptar la oferta del Estado, señora juez.
Mr. Ortiz, will you please raise your right hand?
Ok, señor Ortiz, ¿puede levantar su mano derecha, por favor?
Do you swear or affirm to tell the truth?
¿Usted jura o afirma decir la verdad? Yes.
Do you understand everything we've discussed here this morning?
Señor, ¿usted comprende todo lo que se ha hablado aquí esta mañana? Yes.
You can put your hand down now.
Puede bajar la mano ahora.
And Mr. Ortiz, is anyone forcing you to resolve this matter?
Señor Ortiz, ¿hay alguien que lo está forzando para que resuelva este asunto esta mañana? No.
Are you under the influence of drugs or alcohol?
¿Está usted bajo los efectos de drogas o de alcohol?
No.
No.
Do you need any more time to speak with your attorney?
¿Necesita usted más tiempo para hablar con su abogado?
No.
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
¿Comprende usted que usted tiene derecho de pedir un juicio, pero que está renunciando ese derecho a aceptar esta oferta y declararse hoy? ¿Lo comprende? Yes.
Have you ever been treated for mental or emotional illness?
Señor, ¿alguna vez usted recibió tratamiento por una enfermedad mental o emocional? No.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
¿Y comprende usted, señor, que si no es un ciudadano estadounidense, al declararse hoy, esto puede sujetarlo a la deportación o otros cambios con el Departamento de Inmigración? Yes.
Mr. Ortiz, what plea do you wish to enter, guilty or no contest?
Señor Ortiz, ¿qué declaración quiere presentar? ¿Culpable o no disputó? ¿Perdón?
Will you repeat?
No contest.
No contest.
All right, I accept your plea and find that it is freely and voluntarily given.
Ok, acepto la declaración que fue dada libremente y voluntariamente.
Your sentence will be an adjudication of guilt with time served.
Su sentencia será declararlo culpable y la sentencia de tiempo ya servido.
And there will be a no return order to the location of the trespass. Do you understand?
Y va a haber una orden de que no puede regresar al lugar donde ocurrió la entrada ilícita. ¿Usted comprende?
Okay.
Ok.
All right, good luck to you, sir.
Okay, buena suerte, señor.
Next will be Lazaro Rodriguez Ruiz.
I must be missing some paperwork, 'cause I don't see anything about grand theft other than a vehicle, and I don't see anything about a mask.
I have the same information. Just give me a moment. All right, good morning, Mr. Rodriguez.
Buenos días, señor Rodríguez.
Buenos días.
Good morning.
You're before the court this morning on 4 charges.
Usted está delante del tribunal esta mañana con 4 cargos.
Count 1, burglary of an unoccupied conveyance, unarmed.
Cargo 1 es escalamiento de un transporte no ocupado y sin estar armado.
Counts 2 and 3 are each a separate count of grand theft between $20,000 and $100,000.
Y el cargo 2 y 3 son cargos separados por hurto mayor por la cantidad entre $20,000 y $100,000.
Count 4 is wearing a mask while committing a first-degree misdemeanor.
Y el cargo 4 es usar una máscara mientras cometía un delito menor en el primer grado.
Mr. Linder, as to counts 2, 3, and 4.
On 2 and 3, I'm fine with 2 counts of grand theft auto.
Con 2 y 3 está bien.
I don't see a burglary.
please. All right, as to counts 2 and 3, are those supposed to be Grand Theft Auto?
En cuanto al 2 y 3, ¿se supone que sea hurto mayor?
Yes?
Yes.
Sí, sí.
And as to count 4,
Y en cuanto al cargo número 4,
Your Honor, it's fine to ROR him.
está bien dejarlo salir sin fianza.
I spoke with Detective Shields.
Y yo hablé con la detective, o el detective Shields,
He advised me that both arrestees were wearing masks.
y me indicó que los dos que arrestaron llevaban máscaras.
He failed to address that in the PC.
What? I'm sorry.
He failed to address that in the PC.
Que no lo mencionó en el affidavit de causa probable.
I'm not going to be asking for any time.
Así que no voy a pedir tiempo.
all right, now Mr. Miller.
Finally, Judge, on count 1, I do not see a burglary. I see a car theft.
Y en el cargo 1 yo no veo escalamiento, lo que veo es robo de auto.
Mr. Linder, does the state have a response?
El Estado va a responder.
That's fine, Your Honor.
Está bien.
All right, I'm going to find no probable cause as to counts 1 and counts 4.
Encuentro que no ha habido causa probable en cuanto a los cargos 1 y el 4.
As to counts 2 and 3,
Y en cuanto a los cargos 2 y 3,
I find probable cause as to Grand Theft Auto.
sí encuentro causa probable en cuanto al robo de hurto mayor automóvil.
I'm making that correction on my finding sheet.
Y estoy haciendo esa corrección aquí en mi hoja determinante.
Counts 1 and 4 will be ROR.
En los cargos 1 y 4 habrá libertad sin fianza.
The standard bonds on counts 2 and 3 are $5,000 right now.
Y las fianzas estándar en los otros cargos será $500. I'm sorry, $500 o $5,000?
5,000.
$5,000.
Is the state seeking anything beyond the standard bonds?
¿El Estado procura tener una mayor fianza o no?
Your Honor, even though the standard bond on a Grand Theft Auto is $1,000 each,
Aunque sea el estándar de la fianza en el hurto mayor de auto $1,000 cada uno,
I am asking the court to keep the bonds at $5,000 each,
sí le estoy pidiendo al tribunal que mantenga la fianza a $5,000 cada uno.
plus a GPS monitor.
Y también además un monitor electrónico GPS.
I'm concerned that both Mr. Rodriguez Ruiz and his co-arrestee came to Broward from Dade County to commit this theft.
Me preocupa que el señor Rodríguez y los otros compañeros que fueron arrestados vinieron desde el condado de Miami-Dade a Broward a cometer estos robos.
They got to Broward County in a stolen vehicle.
Y llegaron al condado de Broward en un vehículo robado.
And while it does mention that he is on federal probation,
Y aunque se menciona que él está bajo probatoria federal,
the court should be aware that he is on federal probation
el tribunal debe darse cuenta y tomar nota que sí está bajo probatoria federal
for importing or exporting stolen motor vehicles.
por haber importado o exportado automóviles robados.
This is clearly Mr. Rodriguez Ruiz's MO.
Y claramente esta es ya rutinario para el señor Rodríguez.
All right, Mr. Romero.
Judge, considering the totality of the circumstance, I'm not going to be objecting to a $5,000 bond on each count.
Considerando la totalidad de las circunstancias, no me opongo a que haya una fianza de $5,000.
That's about, if my math's correct, 5 times more than the standard bond, which would have been for a Grand Theft Auto.
Si hubiera sido 5 veces lo que fuera la fianza por un hurto mayor de automóviles,
So I believe that's a reasonable monetary bond.
me parece que es una fianza monetaria razonable.
However, we'd be objecting to the court besides imposing a total of $10,000 if the court also placed him on level 2 pretrial.
Pero estamos oponiéndonos si el tribunal lo pone bajo la fianza de $10,000 y también con los servicios previos a juicio, con esa supervisión.
Now, he's been residing in South Florida for 26 years now.
Ya él lleva 26 años viviendo en el sur de la Florida,
He's 42 years old,
tiene 42 años,
so he's been living here more than half of his life.
así que él lleva viviendo aquí más de la mitad de su vida.
Now, he lives in Hialeah with his wife in an apartment.
Él vive en Hialeah con su esposa en un apartamento.
His wife is not working at this time.
En estos momentos su esposa no está trabajando.
And Judge, my understanding is the last time he had contact, as far as a new law offense, I believe was about 3 years ago.
Me parece que la última vez que tuvo contacto con esta persona, Flores, fue hace como 3 años atrás.
So considering everything, that's why I'm objecting to GPS, but requesting the $10,000 bond.
Y por todas esas circunstancias en su totalidad, me opongo al GPS y pedimos los $10,000 de fianza.
Given the totality of the
Dando las
circumstances,
circunstancias en su totalidad,
including the information regarding Mr. Rodriguez being on federal probation
incluyendo la información de que el señor Rodríguez está bajo la probatoria federal
for charges that involve stolen automobiles,
por cargos que involucran el robo de automóviles o vehículos.
I am going to set the bonds on counts 2 and 3 at $5,000 each.
Sí voy a imponer la fianza en los cargos 2 y 3 a $5,000 cada uno.
And if he does post that monetary bond,
Y si él sí puede prestar esa fianza monetaria,
I am going to require that he be placed on pretrial supervision with a level 2 GPS monitor.
entonces en ese caso voy a pedir que lo coloquen bajo la supervisión previa a juicio con un monitor de segundo nivel.
Thank you. Good luck, Mr. Rodriguez.
Muchas gracias y mucha suerte, señor Rodríguez.
And Judge, we're going to be requesting a photo order.
Y pedimos una orden fotográfica.
That's fine. I will sign that order.
Muy bien, se la voy a conceder y firmar.
Next will be Marcos Ruzan.
Approaching.
Good morning, Mr. Ruzan.
Buenos días, señor Ruzán.
Oh, yeah.
Good morning.
Before we get started, I say to the attorneys, I assume we're going to have similar circumstances in Mr. Ruzan's case
Antes de comenzar, ya veo que vamos a tener circunstancias similares en el caso del señor Ruzán
with regard to counts 2, 3, and 4.
con respecto al 2 y 3.
And 1, I would imagine.
And
so.
1.
Y el 1, el cargo 1 también.
Any additional information on this case?
¿Hay alguna información adicional en este caso?
One moment, Judge.
Okay.
Ok, un momento.
He's on probation. Your Honor, I'm just going to be requesting the same bond and release conditions for his co-arrestee, that he gave his co-arrestee.
Su señoría, voy a pedir la misma fianza y las mismas condiciones que se le aplicaron a su compañero que fue arrestado.
Considering he's on probation out of Palm Beach County for a like offense.
Porque él está bajo probatoria en el condado de Palm Beach por una ofensa parecida.
And Judge, similar to his co-defendant, we're going to be fine with the $5,000 bond on count 2 and 3, but he's under supervision, even a post-bond, he's not going anywhere, he's going to be transferred to Palm Beach, so that's why we don't feel a need for a GPS at this time, Judge.
También no nos oponemos a que tenga $5,000 de fianza en cargos 2 y 3, pero como tiene que regresar a Palm Beach County, no nos vamos a oponer en este momento. Nos oponemos al GPS, perdón.
Record, I'm going to find no probable cause on counts 1 and 4.
Para que conste en las actas, encuentro que no ha habido causa probable en los cargos 1 y 4.
Each of those will be an ROR.
Cada uno de esos serán libertad sin fianza.
As to counts 2 and 3,
Y en cuanto a cargos 2 y 3,
I find probable cause as to grand theft auto.
sí encuentro causa probable en cuanto al hurto mayor de autos.
I've made the correction on my finding sheet.
Y ya he hecho las correcciones en la hoja mía determinante.
On counts 5 and 6,
En los cargos 5 y 6,
which are for a felony probation violation and an out-of-county hold,
lo cual es por una violación de la probatoria federal y detención fuera del condado.
I find probable cause.
Si encuentro que ha habido causa probable,
Those have no bond holds
conllevan detención sin fianza
out of Palm Beach County.
del condado de Palm Beach.
On counts 2 and 3,
En los cargos 2 y 3,
the bond will be set at $5,000 each.
la fianza será $5,000 cada uno.
And if Mr. Ruzan posts that monetary bond,
Y si el señor Russo puede pagar esa fianza monetaria,
he will be placed on pretrial supervision with a level 2 GPS monitor.
lo colocarán en servicios previo a juicio con un monitor electrónico nivel 2.
Good luck to you, Mr. Ruzon.
Ok, buena suerte, señor Russo.
Okay, is there anyone else at Maine that requires a Spanish interpreter?
No, Judge.
Thank you. Anyone at Paul Ryan, Conti, or North Broward that needs a Spanish interpreter? All right, Ms. Bryant, thank you very much.
Thank you.
Okay, let's continue with our list. Next up will be Karan Dalpe.
Please see your present, Judge Maine.
All right, good morning, Mr. Dalpe.
Good morning, Your Honor.
Mr. Dalpe, you're before the court this morning on 3 charges. Count 1, resisting an officer obstructing without violence. 2 is reckless driving. 3 is driving while license suspended, second offense. I find probable cause. I'll hear from the parties.
Judge, we're going to be requesting an ROR. We want to see if the state has an objection before I proceed.
All right. So on count 1, that will be an ROR. Mr. Dalpe, Mr. Romero is going to give you some information to read before you are released today. I need you to understand that that doesn't necessarily mean that's the end of your case. So that means it will be your responsibility to remain in contact with your attorneys in the clerk's office so that you know if there are any future court dates you need to be present for. Do you understand that?
Yes, ma'am.
All right. Thank you very much, sir. Good luck to you. Shannon Holloway. All right. First one of the morning. Daquan Scarlett.
Medical reset.
North Broward.
Okay. Reset him. Gabelin Filsame.
Medical reset.
Brandon Bass.
Medical reset.
North Broward.
All right. Christopher Cozart.
North Broward, Judge.
Good morning, Mr. Cozart.
Good morning.
Mr. Cozart, you're before the court this morning on an ad charge. This is a charge for grand theft between $750 and $5,000. I find probable cause. Is the state seeking anything beyond the standard bond? All right, Mr. Miller, is there anything to add?
Under the circumstances, we have nothing to add, Judge.
All right, so Mr. Cozart, the standard bond on this count is $1,000, so I'm gonna leave that in place at this time. Good luck to you, sir.
Yeah.
Brian LaMadeline.
Maine.
Thank you. Good morning, Mr. LaMadeline. Mr. LaMadeline, you're before the court this morning on an ad charge. This charge is for second-degree petty theft, third or subsequent offense. I find probable cause. Do the parties wish to be heard?
No, Judge.
Judge, I realize he has a VOP no bond hold, but the one thing that Mr. Lamberline wanted to inquire about is when was the alleged date of incident of on this offense and the location?
This is January 14th of this year at Walmart in Pompano Beach.
Thank you, Judge.
All right. I'll leave the standard bond in place in light of the no bond hold. Ulrich Destin,
Maine.
this is just for count 3, correct?
Yes.
He's approaching, Judge.
Thank you. Good morning, Mr. Destin.
Good morning, Judge.
Mr. Destin, you're before the court this morning on an ad charge. This is for an immigration hold. I find probable cause. I believe we discussed this yesterday, but I'm just going to repeat it again in case I didn't say it. Mr. Destin, since this is an immigration hold, that has a no bond hold on it, which means that you'll go before an immigration judge in order to address how that matter is going to be handled. All right? Good luck to you, sir. Isaiah Bavois.
Approaching.
Thank you. All right. Good morning, Mr. Bavois.
Morning.
You're before the court this morning on 4 charges. Count 1, possession of cocaine. Count 2, possession of a controlled substance without a prescription. Counts 3 and 4 are felony probation violations, which have no bond holds. I find probable cause. And Mr. Bavois, I see that you're going to have a hearing with your division judge tomorrow morning to address the violations of probation. So in light of that, do the parties wish to be heard on counts 1 and 2?
Judge, not at this time. I did advise Mr. Bavar that he'll be going to court tomorrow.
Okay, all right. Thank you very much. Good luck to you, sir. Olgerd Wilecki.
Bonded.
All right. Thank you. Jason Nichols.
No problem.
Thank you.
You're welcome.
Good morning, Mr. Nichols.
Morning, Your Honor.
Mr. Nichols, you're before the court this morning on 9 charges. Count 1, failure to stop or remain at an accident involving non-serious injury. 2, leaving the scene of a crash involving damage to property. 3, failure to obey police or fire department. 4, reckless driving. 5, fleeing or attempting to elude law enforcement. 6, driving with a suspended license. 7, criminal mischief greater than $1,000. 8, resisting an officer obstructing without violence. And 9 is burglary of an occupied structure unarmed. I find probable cause for these charges, and I will hear from the parties, beginning with Mr. Linder at this time.
Your Honor, I'm requesting a $5,000 bond on count 1, $5,000 bond on count 9. This is based on the allegations. Also, I have concerns about Mr. Nichols' future appearance in court. He has a warrant outstanding out of the state of Georgia from 2018, failing to appear on a criminal trespass, disorderly conduct. Also out of Georgia. DUI, 2018. Out of the state of Texas, evading arrest and theft, 2012. Out of the state of Kansas. Battery arrest in 2010. He went through a diversion program on that. Out of the state of Florida. ...2015 battery out of Okaloosa County. Nothing further.
Okay, Mr. Miller.
Yes, Judge. Mr. Nichols advises that he has been living in South Florida for approximately 20 years. He's been at the same address for 15 of those years. He works in HVAC, has been doing that since since 2015. He does have a place to stay. He does have family here in South Florida. He has 3 children. He's advising that he is a veteran, 6 years United States Army with an honorable discharge. It is his hope to resolve this case through Veterans Court, and with that in mind, I would ask the court to consider straight pretrial release for him.
Well, based on the nature of the allegations and some of the priors that were given to me, I'm not willing to place him on pretrial supervision at this time. I'm going to set the bonds on counts 1 and 9 at $2,500 each, and I will leave the other standard bonds in place at this time.
Judge, just in order to make this a little easier, can we ROR him on the $100 and $25 bonds?
Not based on the allegations that have been put in place. With respect to the burglary charge, Mr. Nichols, there's going to be a no return order and an order of no victim contact, just so you understand those. That means no going back to that location. And whether you know the alleged victims or not, it means no being in contact with them. So no being in the same place at the same time, no phone calls or text messages, third-party contact, or social media contact. Do you understand?
Yes, ma'am.
All right, thank you very much. Good luck to you, sir. Gregory Saunders,
Page 19, Judge. I have an argument as to count 1.
which facility is he at?
Maine, Your Honor.
Thank you. Good morning, Mr. Saunders. Mr. Saunders, you're before the court this morning on 3 charges. Count 1, grand theft auto. Count 2, resisting an officer or obstructing without violence. 3 is driving while license suspended. Mr. Miller, I will hear your argument.
Judge, I would just argue there's no indication when the car was alleged to have been stolen, and therefore no indication that Mr. Saunders knew or should have known that the car was stolen.
Other than his admission.
Where?
On the second page of the probable cause affidavit, it says Saunders admitted post Miranda to Detective Hopkins to being the driver of the vehicle and knowing it was stolen. I'm going to make a finding of probable cause as to these counts, and I will hear from the parties as to bond.
Judge, considering the totality, at this time, nothing to add from the defense.
Okay.
Considering he was arrested January 2nd for grand theft auto and is out on a $1,500 bond, I'd be asking for a $5,000 bond.
And Judge, Mr. Saunders, right now as it is, he doesn't even think he can come up with 1,000. Things kind of turned around. He has a job interview this upcoming week at the Broward Mall at Chick-fil-A. He believes with that job things are going to go better for him, but right now he doesn't even think someone can post $1,000, but because of what Mr. Lender stated, that's why I wasn't going to be requesting a bond reduction or a pretrial. We were going to hopefully see maybe if his family, through the help of a bondsman, can come up with something.
2018 burglary dwelling grand theft auto, 2018 grand theft auto, 2016 burglary of a dwelling.
All right, the bond on count 1 will be set at $1,500. Thank you. Good luck to you, sir. Shiva Denny Ramutar.
Come on up. He's approaching, Judge.
Thank you. Good morning, Mr. Ramutar.
Good morning.
You're before the court this morning on 1 count, possession of THC. I find probable cause, and I'll hear from the parties.
Judge, before I proceed, I'm going to be requesting an ROR, so I'll see if the state has an objection.
It's fine.
All right. Okay, so I'm going to place the ROR. Mr. Ramutar, a couple of things for you to understand, okay? Mr. Romero is giving you some information there. You need to make sure that you read it after we're done here. You're going to be released today, but I need you to understand that though you are going to be released, that doesn't necessarily mean that that's the end of the case. So it will be your responsibility to be in contact with your attorneys in the clerk's office so that you know if there are any future court dates you have to be present for. Do you understand that?
Yeah.
Okay. All right. Thank you very much. Good luck to you.
Wait, hold on.
Brandley Desamores.
He's approaching, Judge.
Thank you. Good morning, Mr. Desamores.
Good morning.
You're before the court this morning on a violation of parole. I find probable cause, and Mr. Desamores, because this is a parole violation, it has a no bond hold on it, which means that you'll go before the parole board in order to address this matter further. Good luck to you, sir. Edwin Lopez.
He's approaching, Judge. Maine.
Thank you. Good morning, Mr. Lopez. You're before the court this morning on 2 charges. Count 1, possession of THC. Count 2, trespassing on an unoccupied structure or conveyance. I find probable cause, and I will hear from the parties.
We're just going to be requesting a phone order, Judge.
Okay, that's fine. Anything further from the state?
No, Judge.
All right. Thank you. Jeffrey Paul.
North Broward.
Thank you. Good morning, Mr. Paul.
Hey,
Mr. Paul, you're before the court this morning on 2 charges. Count 1 is criminal mischief between $200 and $1,000. Count 2 is a felony probation violation, which has a no bond hold. I find probable cause. And Mr. Paul, I do see you're going to have a hearing with your division judge tomorrow morning to address the violation of probation. So in light of that, I'm going to leave the $100 bond in place on the other charge, all right?
all right. So do you think tomorrow when I'm meet up with the other judge that she'll be able to release the hold on the violation?
It'll be up to her to do that. She's going to discuss it with you and decide what she wants to do, okay?
All right.
All right, good luck to you, sir.
All right, thank you.
Chaz Jackson. All right, thank you. Milad Ibrahim.
No problem.
Thank you. Good morning, Mr. Ibrahim. You're before the court this morning on 5 charges. Count 1, trafficking methamphetamine between 14 and 28 grams. Count 2, possession with intent to sell, manufacture, or deliver alprazolam. Count 3, possession of a controlled substance without a prescription. Count 4, possession with intent to sell, manufacture, or deliver amphetamine. Count 5, possession or use of drug paraphernalia. I find probable cause for these charges, and I will hear from the parties at this time.
Your Honor,
Yes.
I spoke with Mr. Scott Miller, who is Mr. Ibrahim's attorney. He is in court in Miami today and asked if the court could reset this hearing to tomorrow p.m.
Okay. All right. What I will do is this. Mr. Ibrahim, since you have private counsel, I'm sure you just heard what Mr. Miller told me. Since your private counsel, also Mr. Miller, isn't able to be here today, I'm going to reset this hearing to tomorrow afternoon. So you'll come back to me tomorrow, and your attorney will be here so that he can represent you, all right?
Okay.
All right. Thank you very much.
Thank you, Judge.
Tomorrow afternoon. It's fine. Just leave it in place. I'm sorry? That's correct. It's Thursday, so it might be a little bit later. Matthew Iltius.
He's approaching, Judge. Maine. Come on
Thank
up,
you.
sir.
All right. Good morning, Mr. Iltius.
Morning, Judge.
You're before the court this morning on 2 charges. Count 1, grand theft between $750 and $5,000. Count 2 is fraud, uttering a false instrument. I find probable cause, and I will hear from the parties.
Judge, speaking of Mr. LTS, I'm going to be requesting an R warrant on his behalf. My understanding, this is his first time being arrested. He's a registered voter. He's been here his whole life. He's 20 years old. He's a graduate of Piper High School class of 2017. Right now he is working. He works for a company called Teleperformance. He's been there for 1 year. Besides that, he's going to Broward College, where he's pursuing a degree in criminal justice. He has a 2.8 GPA, and when he graduates, what he wants to do is get into law enforcement. He's looking forward to having his day in court and clearing his name on these allegations. He lives in Tamarack. He's been residing in the same location for his whole life. He lives there with his mom and his other sibling. His mom's a single mom. She's a caretaker. Judge, based on these being nonviolent offenses, his strong ties to community, his lack of criminal priors, I'm going to be requesting an ROR on his behalf.
Your Honor, I'd have no objection to pretrial based on the amount of money alleged and also the allegations that this is a business that has been suffering from multiple fraud issues recently, and just based on the circumstances of this case.
Okay. So based on the circumstances, I'm willing to ROR him and just place him on standard pretrial. So do you want to discuss that with him, Mr. Romero?
Thank you, Judge, for giving me the opportunity. Judge, he wishes to accept pretrial.
Okay. All right. Mr. Iltius, I'm going to ROR you on both charges so that you can be put on standard pretrial. Mr. Romero is going to give you some paperwork there that you'll need to read after we're done today so that you understand, though you're going to be released today, you must report to pretrial supervision within 24 hours. If you fail to report to them as I have instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
Okay. All right. Thank you very much. Good luck to you. James McCall.
He's approaching, Judge.
Judge, I know the court reads these probable cause affidavits, and you would have noticed that Mr. McCall is claiming self-defense in this PC. I'd just like to point out that the alleged victim in this case has a history of violence.
I'm objecting, Your Honor.
Okay, first of all, I haven't even read the charges yet, and I hate when you guys do that. So please just wait. Good morning, Mr. McCall.
Good morning, Judge.
Mr. McCall, you are before the court this morning on one charge of abuse of an elderly or disabled adult without great harm. Is there a probable cause argument?
Simply asking the court to take into account that this claim for
I understand. I saw that there's a claim of self-defense. I did read it. All right, I'm going to find probable cause, and I will hear recommendations as to bond and release conditions. We'll start with the state.
Thank you, Your Honor. I'm going to be requesting a $7,500 bond. No victim contact, considering the allegation that the victim that Mr. McCall attacked is in a wheelchair. Also noting while he claims self-defense, there's a witness that corroborates the allegation that Mr. McCall attacked him first. There's also cell phone video evidence. One moment, Your Honor. That shows the defendant striking the victim several times until the victim was knocked out of his wheelchair. I see he's got a pending violation in county ordinances, I believe. Theft from 2016. Moment, Judge. Paraphernalia 2018. Nothing further, Judge.
Carol?
Judge, there's no way Mr. McCall is going to be able to afford $7,500. My understanding, he's homeless. I did advise him the court's going to be instructing him as far as no contact with the alleged victim. My understanding is the alleged victim is also homeless. So Mr. McCall will say he won't even go back to that area in order to abide by the court order to make sure he has no sort of contact with that person. But he is maintaining he was defending himself. He himself has his own witness that he's going to get in touch with, talk to his attorney. But Judge, right now, the only person that can help post his monetary bond is his wife, and she's homeless. But she's going to try and see what she can do as far as try and post his monetary bond. So we're respectfully going to be asking for a $1,000 bond on his behalf. Now, he's been here his whole life. He did advise me that he can get mail at 2020 Scott Street, which I've learned from yesterday is the Jubilee Center, and that's where he advised me he can get mail to make sure he goes to court. But he's not going to be able to afford $7,500. That's why he's requesting $1,000, Judge.
Does he have any prior failures to appear, Mr. Linder?
He was arrested about 2 weeks ago on a capias. Another one in 2019. Another one in 2019.
All right, I'm going to set the bond at $3,500. There will be an order of no victim contact. Mr. McCall, based on what I've heard, I'm sure Mr. Romero has discussed this with you, but so that you hear it from me, the no victim contact order means whatever the situation is, no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that? All right, thank you very much. Good luck to you. Dario Hepburn.
Bonded?
Judge, I think that should be cocaine.
Yeah, I was just gonna ask. I think it was just a mistake on the booking. On count 1 for Hepburn, I think it's supposed to be cocaine. Is that correct?
Yes.
All right. Okay. Jose Elize.
Mr. Elize is here present. Come on up, Mr. Elize.
His bond has
Judge.
been posted. His bond has been
bonded.
posted. Thank you. Jarvis Cure.
Mr. Cure, come on up, please.
Good morning, Mr. Cure.
Good morning, Your Honor.
Mr. Cure, you're before the court this morning on one charge of possession of cocaine. I find probable cause, and I will hear from the parties.
Judge, nothing to add. I'm going to be contacting his girlfriend and post his monetary bond.
He's currently being supervised by pretrial services. In case 19-8808 CF-10A, 2 counts of felony battery with prior conviction and 2 counts of criminal mischief. I know he's here as Jarvis Cure, but we also have him as Christopher Bush, whatever name he's using. We're going to ask the court, based on finding a probable cause, to revoke his pretrial supervision at this time.
When was he placed on pretrial in this case?
September 12th of last year.
September 12th, 2019.
Judge, when was he placed on pretrial?
September 12th of 2019.
Correct. He was fixing the electronic.
Judge, in speaking Ms. Cure, I'm certain pretrial, correct me if I'm wrong, you believe this is the first violation of pretrial, considering this is a nonviolent offense and nothing similar to what he had, that he was on supervision for? I'd ask you to not take any action on the case. He's currently on supervision.
I don't know really what it means by saying it's a first. There's not supposed to be any violations. That's why Mr. Romero, when he asked for pretrial on second look, says, well, Judge, if you put him on pretrial, he knows what will happen if he doesn't show up or commits a new law offense.
All right, I tell you what I'm going to do. I'm going to grant pretrial's request to revoke his pretrial services. I'm just going to read the case number again. It's 198808 CF10A. That doesn't mean that I'm holding him no bond on that case, so I will hear your recommendations on that case at this time.
Judge, Mr. Cure works in landscaping. His girlfriend Jennifer was intent on calling. My understanding, she's a associate at Macy's, basically making about minimum wage. I'm going to be requesting on the case that he's currently on supervision. a total of about $1,500 bond on that case.
Your Honor, I'm gonna be, requesting $2,500 bond per count. One, considering he was actually being held no bond when Judge Allspector put him on pretrial because he failed to appear in court on that case. Secondly, unless the court, is gonna place him, I don't know if the court's gonna place him back on a GPS monitor or not, but that's something that should be taken into consideration.
Is he on a GPS monitor now?
He was on a GPS monitor when this happened, allegedly.
All right, on the case that was on pretrial, I'm going to set the bond at $2,500 per count. The case that's before me today on the possession of cocaine, I'm gonna leave the standard bond in place. Thank you. DeQuan Charles.
Mr. Charles, come on up, please.
Good morning, Mr. Charles.
Good morning.
Mr. Charles, you're before the court this morning on one charge of dealing in stolen property. I find probable cause, and I will hear from the parties.
Your Honor, I'm requesting that the court set the convenience bond for dealing in stolen property, $3,500. Mr. Charles has 2 prior robberies with firearms, one in 2015, one in 2009. Also in 2015, possession of firearm by convicted felon, and fleeing and eluding in 2013.
That's reasonable, Judge.
All right. The bond will be set at
What's the person's name?
$3,500.
Camille.
Okay.
Camille, and what's the phone
Thank
number?
you. Good luck, Mr. Charles.
Thank you. 285.
Your Honor,
Yes.
60.
Yes.
before we move
73.
too far down the road on
I'll call her as soon as I
Mr.
get out here.
Cure,
Yes.
is the court aware
your
that
mom,
there are
sister,
4
or-
counts, 2
Hold on
of
a
them?
second. Mr. Romero, can you
Fiance.
turn your mic off, please?
Oh, sorry.
That's okay.
Is
Yes.
the court aware there are 4 counts, 2 of them are misdemeanors?
Which case are we talking about?
Mr. Cure's, you just revoked the pretrial. He's got 2 counts of felony battery and 2 counts of criminal mischief. Your Honor set it at $25 per count.
500 per count.
So $10,000 is what the court meant to do?
Yes.
Yes, ma'am. Thank you.
Thank you. All right, Steven Syriacs. Is he still? Okay, he's still medical reset?
Yes, ma'am.
All right, thank you, Deputy.
You're welcome.
Okay, next up, Timothy Fullwood.
He's approaching Judge in Maine.
Okay, and I want to make sure we get these right because I know we have a combination of add charges and changes of charge. Good morning, Mr. Fullwood.
Good morning, Judge.
All right, so to start off, and I will make sure that this is all correct.
Judge?
Go ahead.
Before you go too far, I'm showing he has a private attorney that's filed a notice of appearance in this case.
I did not reach out to his private attorney, Judge. I'm gonna look it up now.
He is Marco Quesada.
Mr. Romero?
Judge, Mr. Fullwood did advise me of that, but he thought he only retained him for purposes of arguing a bond reduction, not to be on the case officially.
And
But I don't know what that, usually in the notice of appearance, it would say for the limited purpose. I don't know if that language is omitted and he's now on the case, so that I don't know.
Okay, let's just have a look.
He's not.
Judge,
But we gotta see, that's what I'm asking.
Mr. Quesada did file a temporary notice of appearance, and the
Yes.
public defender is still the attorney of record.
Okay, all right. Okay.
Your Honor, there's also a substitution of counsel. Where it says that it's a motion for substitution in counsel. It says Marco Quesada has been retained by Timothy Fullwood to represent him in the above style case. This motion is made in good faith and not for purpose of delay. Attorney Patil Flazian from the Public Defender's Office has been contacted regarding this motion and stipulates to the substitution in the signed attached document.
Is there an order on that motion?
I have a stipulation.
I can advise the court is the public defender is still the attorney of record.
Probably because there's not an order.
And it is as Mr. Linder indicated, but there is no order on that yet.
Your Honor, if Mr. Fullwood wants to proceed with the public defender for this hearing, that's fine. I just wanted the court to be aware what I'm seeing.
All right, I'm going to ask Mr. Fullwood what it is he wants to do.
She's gonna ask you a question.
All right, Mr. Fullwood, have you been listening to the conversation that's been going on? There, okay. You understand?
Yes, ma'am.
All right, and you understand what Mr. Linder just told me, that there is a signed stipulation saying that Mr. Quesada is coming in as your attorney of record on this case?
Yes, ma'am, but can I explain, like, that situation?
Well, that's what I'm gonna ask you. So I'm gonna ask you is this, you're here today for this hearing. If you want to proceed with the public defender representing you, that's fine with me, but I need to make sure that you understand everything that's going on, and it's going to be your decision as to how you want to proceed. Do you understand everything I've said so far?
Yes, ma'am.
Okay, so what do you want to tell me?
No, the motion for the substitute attorney, that was just the motion just in case Mr. Marco wasn't able to come. And that attorney will be able to represent me on the bond reduction case.
Okay, all right.
He was not.
So what do you want to do today? Do you want to use the public defender, or do you want me to reset the hearing so that your private attorney can be here?
I want to proceed.
Okay, all right, that's fine. Okay, so now let me make sure that we have the correct charges that are being changed and added. On count 1, Mr. Linder, I'm showing that it was originally showing as premeditated murder. It's being changed to attempted first-degree murder. Is that correct?
They might be at some point. Your Honor, on count 1, guys, please. You said it was originally attempted murder. You said a bond of $250,000.
Okay.
On count 2, you set the bond at $50,000.
Okay, that's the discharge of the firearm?
Yes. On 3, you set it at $50,000. 4 and 5 are add charges.
Okay.
You also set the following conditions: pretrial release, GPS monitor level 1, no victim contact, no possession of any weapons, firearms, ammunition. I'm going to be requesting that Your Honor set the bonds on the 3 add charges at $50,000 each. Your Honor, this was, you may recall, this was original arrest was based on an arrest warrant. There was an altercation at a gas station. The victim was looking for directions to a casino. He later drove away. There was a witness that saw the same type of vehicle that Mr. Fullwood was driving, and shots were fired from that vehicle. The victim was shot and ended up being paralyzed as a result of the shooting.
I remember the case. Mr. Fullwood, we've addressed the 3 charges that you've already been here on before. I'm going to read to you the 3 add charges. Excuse me, the 3 add charges, all right? On count 4, that is burglary of a dwelling structure or conveyance armed. Count 5, throwing or shooting a missile into a dwelling, vehicle, building, or aircraft. 6 is for fleeing with disregard of safety to persons or property. I find probable cause as to those. The state has requested $50,000 bonds on those counts, so at this time, I will go to Mr. Romero. We'll hear from you.
One moment, Judge. Let me just make sure Mr. Fullwood understand what's going on.
Okay.
Judge, just to let you know, the state has filed a designation for assignment to career criminal court. Mr. Fullwood will be arraigned before Judge Bober on March 9th, I believe.
Judge, I've had an opportunity to speak to Mr. Fullwood. As you see, he's been in custody for quite some time now. We don't object as far as the other bond release conditions that are already imposed on 1, 2, and 3 to be imposed on 4, 5, and 6, level 1 GPS. But as far as adding an additional $150,000, that's going to be something very, very difficult for Mr. Fullwood. Now, before he was incarcerated, he was looking for work. Now he lives in Pompano Beach with his grandmother. His family are going to do everything possible to help him out. My understanding, his grandmother's elderly. His cousin is working. He works for a moving company. Now he's been here his whole life. Judge, what we're going to be asking, considering he's going to be on level 1 GPS, we're going to be asking for $10,000 bond on counts 4, 5, and 6 on each count.
Someone over there.
I understand everything that you've just told me, Mr. Romero. As Mr. Fullwood, I'm sure, has told you. Based on what Mr. Linder has told me, his arraignment hearing has already been set for March 9th. And in light of the fact that I'm not sure if there was already a hearing that was had on the bond reduction or not, was there?
There was, Your Honor. The defense filed a motion before Judge Colra for a
Yeah.
bond reduction. He denied it and felt the bonds that Your Honor said were appropriate.
Okay. All right. Since he's going to be going in front of his division judge to address this matter anyway, and considering the bonds on counts 1 through 3, I'm going to go ahead and set the bonds on 4 through 6 at $50,000 each, so that if there is an issue with regard to the bond that needs to be addressed, then he can address all of it at the same time with Judge Bober. All right. And Mr. Fullwood, as I said, you're going to have that hearing on March 9th. Today is the 4th, so that's in a few days. I am going to leave all of the other conditions in place that were already set, and I'll just repeat those for the record. If Mr. Fullwood posts the monetary bond, he would be placed on pretrial supervision with a level 1 GPS monitor. There is an order of no victim contact, as well as an order that Mr. Fullwood possess no weapons, firearms, or ammunition. And so those conditions of release will apply to counts 4 through 6 as well. All right. Mr. Fullwood, thank you very much. And as I said, once again, you're going to see the division judge on March 9th for the arraignment hearing.
Yes, sir.
All right. Thank you. Good luck to you. All right, that brings us to the end of our docket for this morning. I'll see everyone back here at 1 o'clock for the afternoon docket.